It was 11:40 on a Tuesday night when a police officer reached into his own jacket pocket, pulled out a small plastic bag of white powder, and dropped it beneath the driver's seat of a parked sedan, a car he believed belonged to a stranger he could quietly destroy. He was wrong about almost everything that mattered that night. He was wrong about who owned the car. He was wrong about how carefully she was watching him through her rearview mirror the entire time. And he was most wrong of all about how patient she was willing to be before she finally let him hang himself with his own sworn testimony, in open court, in front of a jury, under oath. Her name was Assistant District Attorney Camille Reyes. 6 weeks later, that same officer would stand at a witness stand, raise his right hand, and tell a lie so specific, so confidently detailed, that it would end his career, his freedom, and an investigation into a pattern of evidence fabrication stretching back nearly 7 years. A lie he never would have told if he'd known that Camille had been building a case against him from the very first second she watched him plant that bag through her mirror. This is the story of what happens when someone decides not to fight back in the moment, and instead spends 6 patient weeks making sure the trap closes so completely that there's no way out of it at all. Stay with us, because by the end of this story, you're going to understand exactly why the most dangerous thing you can do to a corrupt system isn't to expose it immediately. Sometimes, it's simply to wait. Every corrupt officer who has ever fabricated evidence has counted on the same basic assumption, that the person on the other end of that fabrication will react immediately, emotionally, and without the kind of documentation that actually survives scrutiny months later. That assumption has protected officers like this for years, in departments across the country. It was about to meet someone who understood, better than almost anyone else who could have been driving down that particular street that night, exactly how thoroughly that assumption needed to be proven wrong. Camille Reyes had been an assistant district attorney for 9 years, building a reputation in her office for a particular kind of case that most of her colleagues actively avoided. Officer-involved misconduct prosecutions, the kind of cases where the state's own witnesses were sometimes the very people who wore the same uniform as the officers being investigated. It was thankless, politically dangerous work. It made her unpopular with certain corners of the local police union. It also made her, according to colleagues who worked alongside her for years, one of the most meticulous prosecutors in the entire office. Someone who never brought a case to trial until she had built it so thoroughly that there was functionally no room left for a defense attorney or a corrupt witness to find an exit. Colleagues who worked closely with Camille over the years often described her preparation process using nearly identical language, regardless of who was asked. She was known for building what one fellow prosecutor called belt and suspenders and a third belt, case files, documentation so thorough, cross-referenced, and redundantly verified that even the most aggressive defense challenges rarely found any genuine procedural gap to exploit. She kept, for every major case she handled, a private timeline document, tracking not just the evidence itself, but every single moment any piece of that evidence changed hands. A habit she'd developed early in her career, after watching a case she cared deeply about collapse due to a minor, avoidable chain of custody gap that a more careful prosecutor could easily have prevented. She had grown up the daughter of a public defender, watching her own mother spend decades representing clients who often had no other advocate willing to take their case seriously. Camille had initially planned to follow the same path, but a formative internship during law school, spent reviewing wrongful conviction cases tied to fabricated evidence, redirected her focus entirely. She decided, somewhere during that internship, that she wanted to work from inside the prosecutor's office instead, not to defend the system as it existed, but to hold it to the standard it claimed to already meet. "I used to think prosecution and defense were opposite sides of the same fight," she said once, during a law school guest lecture, recorded years before the events of this story. "What I actually learned is that the real fight isn't between prosecution and defense. It's between people who are willing to cut corners because they believe the ends justify it, and people who refuse to, even when cutting the corner would be easier. I decided a long time ago which side of that fight I wanted to be on, regardless of which side of the courtroom I was sitting on. That Tuesday night, Camille had worked late, preparing for an unrelated trial, finally leaving her office parking garage just before 11:30 p.m., exhausted in the particular way that only a demanding trial schedule combined with a toddler at home waiting for her could produce. She parked her sedan on a quiet residential street 2 blocks from her apartment. Her assigned garage spot had been under repair for nearly a week, and sat in her car for several minutes after parking, scrolling through emails on her phone before heading inside, a habit she'd developed years earlier as one of the only quiet moments in her day. It was during those several minutes, sitting in the dark with her phone's glow the only light inside the car, that she noticed a patrol vehicle slow down and park roughly 30 feet behind her, its headlights off. Camille had no reason, in that moment, to feel any particular alarm. Officers parking on residential streets at night wasn't unusual. What caught her attention, and what she would later describe as the single detail that changed everything about how she chose to respond over the following weeks, was watching, through her rearview mirror, an officer exit his vehicle, approach her car from the passenger side rather than the driver's side, and crouch briefly near her front passenger door before straightening and walking back to his own vehicle. She sat perfectly still, watching the entire sequence unfold in her mirror, her prosecutor's instincts, sharpened by 9 years of reviewing exactly this kind of misconduct in other people's cases, immediately recognizing the shape of what she was almost certainly watching happen to her own vehicle, in real time. Her first physical reaction, she later admitted, was her heart rate climbing sharply, an almost overwhelming urge to throw open her door and confront him directly while he was still close enough to be caught in the act. She has said, in the time since, that the several seconds it took her to consciously override that instinct were among the hardest of the entire ordeal. Not because staying still was physically difficult, but because everything in her, in that moment, screamed at her to react immediately. I remember consciously telling myself, out loud, quietly, in the car, "Not yet," she said. I didn't know exactly what I was going to do instead. I just knew, with absolute certainty, that whatever I did next needed to be something I couldn't take back or undo by acting impulsively in the next 30 seconds. What Camille did next was the first of many decisions over the following 6 weeks that would ultimately define the entire outcome of this story. She did not get out of her car. She did not confront the officer. She did not immediately call anyone. She simply sat still, watched him return to his patrol vehicle and drive away, and then, once he was gone, retrieved a small flashlight from her glove compartment and carefully examined the area beneath her passenger seat, where she found exactly what she suspected she would find: a small, sealed plastic bag containing a white powdery substance, tucked just far enough beneath the seat to be discovered during any subsequent search, but positioned in a way that made clear it had been placed there in the preceding minutes, not left behind by any prior occupant of the vehicle. Camille photographed the bag exactly where it sat, using her phone, capturing multiple angles along with timestamps, and, critically, a brief video panning from the bag itself to her car's dashboard clock, establishing an unambiguous, verifiable record of exactly when and where the discovery occurred. She then, using a pair of disposable gloves she happened to keep in her car's emergency kit, a habit from years of handling evidence professionally, even outside of work, carefully removed the bag, sealed it inside a clean container, and drove immediately to a 24-hour urgent care facility roughly 15 minutes away, specifically choosing a facility outside her own city's jurisdiction, rather than any hospital where local officers might have informal relationships with staff. The drive to that facility, she later said, was one of the strangest 20 minutes of her life, her hands steady on the wheel, even as her mind raced through every possible way the encounter could unfold. If she made even one procedural mistake in how she handled what she now considered, in the most literal professional sense, active evidence in a potential criminal case, she mentally rehearsed, During that drive, the exact chain of custody language she would need to use at intake, drawing directly on the same standards she had spent 9 years holding other officers and investigators to in her own casework. At the urgent care facility, she requested, under her own name and with full documentation, an official chain of custody intake for what she formally described as suspected evidence tampering related to a public corruption matter, invoking a specific administrative protocol she was aware of, through her professional role, that most ordinary citizens would have had no idea even existed. The night intake nurse who processed her request later recalled, once the case became public, being struck by how calm and precisely worded Camille's request was, despite the late hour, and what the nurse could tell was clearly a distressing situation. She wasn't panicked, the nurse said. She was specific. She knew exactly what forms she needed filled out, exactly what language needed to appear on the intake report. I remember thinking, this is someone who has done this exact kind of paperwork professionally, just never as the person the paperwork was actually about. The substance was logged, sealed, and transferred the following morning to an independent forensic laboratory Camille had worked with previously on unrelated cases, specifically chosen because it had no existing relationship with the police department she now suspected was involved. What Camille did not do, in the days that immediately followed, was report the incident through her own office's standard internal channels, a decision that, once the broader case unfolded months later, drew some initial scrutiny from colleagues who questioned why she hadn't immediately escalated what appeared to be a serious act of evidence fabrication targeting a sitting prosecutor. Camille's own explanation, given later during formal proceedings, centered on a specific concern she had developed over years of prosecuting officer misconduct cases, that premature exposure, before a full pattern could be established, often allowed individual officers to simply claim isolated misunderstanding or procedural error, protected by union representation and institutional reluctance to pursue aggressive discipline against a single incident lacking broader context. I had seen this exact dynamic play out in other cases I prosecuted, she said. An officer gets caught doing something clearly wrong, in isolation, and the response is a 2-week suspension and a quiet return to duty, because nobody can prove it wasn't just one bad night. I didn't want one bad night. I wanted to understand exactly what I was looking at, and exactly how far back it went, before I did anything that would give him the chance to explain it away. Camille began, over the following days, a careful, methodical review of the officer's identity and history, information she was able to access relatively quickly given her position, cross-referencing his patrol assignment records against her own case files to determine whether any prior connection existed between them. What she found, within the first week, was that the officer, a 12-year veteran named Sergeant Wade Kessler, had been the arresting officer in a drug possession case Camille had declined to prosecute nearly 4 months earlier, after reviewing evidence that she determined, in her professional judgment, was insufficient to meet the standard required for prosecution, a decision that, according to internal office records, Kessler had formally and vocally objected to at the time, filing a written complaint with his own supervisor, expressing frustration that the DA's office keeps letting guilty people walk based on technicalities. That connection, once established, gave Camille what she considered her first genuine window into a possible motive, not proof, but a plausible thread suggesting Kessler's actions that Tuesday night may have been retaliatory, targeting her specifically because of a professional decision she had made months earlier, rather than a random act connected to any broader pattern of misconduct. What Camille discovered next, over the following 2 weeks of careful, quiet research, conducted largely outside her normal working hours, and specifically avoiding any use of her office's internal systems that might generate a record alerting anyone to her investigation, expanded that initial thread considerably. Reviewing publicly available case outcomes and court records connected with Kessler's arrests over the preceding several years, cross-referenced against defense attorney complaints she was able to access through professional channels, Camille identified a pattern that echoed uncomfortably with what had just happened to her own vehicle. At least 6 prior cases, spanning nearly 5 years, in which defense attorneys had raised formal, documented concerns about the circumstances under which physical evidence had been discovered during Kessler's traffic stops and searches, concerns that, in each case, had ultimately been dismissed or gone unaddressed, either because the defendant lacked resources to pursue the challenge fully, or because the presiding judge in each individual case had found insufficient grounds to exclude the evidence based on the specific arguments presented at the time. Camille spent several of those research evenings, after her daughter had gone to sleep, at her kitchen table with printed copies of the 6 case files spread out in front of her, building a comparison chart tracking the specific language each defense attorney had used to describe their concerns, the exact circumstances of each search, and the outcome of each individual challenge. What emerged from that chart, once fully assembled, was a level of procedural similarity across the 6 cases that struck her immediately as far beyond coincidental, nearly identical phrasing in Kessler's own incident reports, describing evidence as plainly visible or in open view during searches that, in several cases, defense attorneys had specifically challenged as lacking the probable cause that would have made such visibility legally relevant in the first place. One case in particular, involving a young man named Terrence Boyd, who had spent 8 months in county detention before ultimately accepting a plea deal rather than risk a longer sentence at trial, struck Camille as especially difficult to read, precisely because Boyd's original defense attorney had raised concerns nearly identical to what Camille herself had now witnessed happen to her own vehicle. Concerns that, at the time, a judge had found insufficient to exclude the evidence, given the lack of any independent verification beyond Boyd's own account. Reading his file, I remember thinking, "I have exactly what he didn't have," Camille said later. "I have a time-stamped video. I have an independent lab. I have professional knowledge of exactly which channels to use." He had his own word, an overworked public defender, and a judge who had no reason, at the time, to doubt an officer's report over a defendant's denial. That gap between what I could prove and what he could prove was never about whether we were telling the truth. It was entirely about resources and knowledge. That distinction bothered me more than almost anything else I found during those 2 weeks. None of those 6 prior cases, examined in isolation, had ever risen to the level of triggering a formal internal affairs investigation into Kessler's conduct. Each had been treated, exactly as Camille had anticipated based on her own professional experience, as an individual defense argument that ultimately failed to persuade a judge, rather than as part of a broader pattern that, once properly connected, painted a considerably more troubling picture. Camille made a decision, roughly 3 weeks after the initial incident, that would prove central to everything that followed. Rather than filing a complaint immediately, she would wait for an opportunity to observe Kessler's conduct directly, in a setting where his own sworn testimony could be captured, recorded, and later compared against the physical and circumstantial evidence she had already independently gathered. That opportunity arrived sooner than she anticipated. Roughly 4 weeks after the incident involving her own vehicle, Kessler was scheduled to testify as the arresting officer in an unrelated drug possession trial, a case Camille had no direct involvement in prosecuting, but which, through her position, she had legitimate professional access to monitor as an observer, given her office's general interest in tracking officer testimony patterns across cases. She attended that trial's proceedings quietly, seated in the courtroom gallery rather than at the prosecution table, taking careful notes as Kessler testified under oath about the circumstances of an unrelated arrest. Testimony that, while not directly connected to what had happened to Camille's own vehicle, gave her a critical additional data point, a clear, detailed, sworn baseline of exactly how Kessler described his search and evidence discovery procedures when testifying formally in court, language and procedural claims she could later directly compare against whatever testimony he might eventually give regarding her own case, if and when it ever reached a courtroom. What Camille was ultimately building toward over these patient weeks of quiet observation and independent evidence gathering was not simply a complaint against Kessler for what he had done to her personally. It was a fully documented pattern case, one that, if properly assembled, could not be dismissed as an isolated misunderstanding, protected by procedural technicalities, or quietly resolved through informal disciplinary action behind closed doors. The final piece of that case fell into place roughly 5 weeks after the original incident, when Camille, working through proper formal channels for the first time since the night her own vehicle had been targeted, filed a detailed, comprehensive complaint simultaneously with her own office's ethics division, the police department's internal affairs unit, and, critically, the state's attorney general's office. A triple-track filing strategy specifically designed, she later explained, to prevent any single institution from being able to quietly manage or minimize the complaint, without the others becoming aware of exactly what had been reported. That filing included the original photographic and video evidence from the night of the incident, the independent forensic laboratory's report confirming the substance's composition, and the chain of custody Camille had personally established, the documented connection to the case she had declined to prosecute months earlier, and the pattern of 6 prior defense complaints she had independently identified and compiled during her weeks of quiet research. Kessler was placed on administrative leave within 72 hours of the complaint reaching all 3 institutions simultaneously, a response speed that several colleagues later noted stood in stark contrast to how the 6 prior individual complaints against him had each been handled in isolation over the preceding years. What happened next, however, was the moment Camille had been most carefully anticipating throughout her entire 6-week process. Kessler, informed of the administrative leave, but not yet given full access to the specific evidence Camille had compiled against him, standard procedure during an active investigation, intended to prevent any tampering with the ongoing inquiry, was called to give a formal sworn statement regarding the incident, roughly 10 days after his administrative leave began, as part of the internal affairs investigation process. In that sworn statement, Kessler offered a detailed, specific account of that Tuesday night, one that directly contradicted the evidence Camille had already gathered in ways he had no way of knowing she possessed. He testified, under oath, that he had approached Camille's vehicle that night in response to a specific dispatch call regarding a reported suspicious vehicle matching her car's description, a dispatch call that, once internal affairs investigators formally requested the department's actual dispatch logs for that exact time frame, turned out never to have existed at all. He testified that he had observed through the vehicle's window using his flashlight what appeared to be a partially visible plastic bag already present on the passenger side floor before he ever approached the vehicle, a claim directly and unambiguously contradicted by Camille's own time-stamped video, which showed no such bag present at any point before Kessler's approach, and clearly captured him crouching near the passenger door in the specific manner and time frame inconsistent with simply observing something already there. The internal affairs investigator conducting that sworn interview, a 14-year department veteran named Lieutenant Frank Castellano, later described the session as one of the more unsettling experiences of his career, precisely because of how confidently and specifically Kessler answered each question, apparently entirely unaware of exactly how much verifiable evidence already existed to contradict him. He wasn't nervous. He wasn't hedging, Castellano said in testimony given during the later criminal proceedings. He answered every question like a man who believed he had nothing to worry about, because as far as he knew, it was his word against a private citizen's word, with no video, no independent evidence, nothing beyond what he assumed would be a routine he said, she said dispute that would resolve in his favor the way it always had before. He had no idea what we already had sitting in the file in front of me. Most critically, Kessler testified, in specific and confident detail, that he had never previously had any professional interaction with Camille Reyes, and had no knowledge of any prior case connection between them, a statement directly and provably false, given the documented written complaint he had personally filed with his own supervisor 4 months earlier, specifically naming Camille and expressing frustration over her decision not to prosecute a case he had made an arrest in. That final false statement, made confidently and specifically under oath, with no hedging or uncertainty in his language, became, according to the prosecutors who later handled the resulting perjury case, the single most damaging piece of evidence in the entire proceeding. Not because it was the most serious underlying act, but because it was so easily, definitively, and embarrassingly disprovable, given that the written complaint existed in Kessler's own department's official records, filed in his own name, 4 months before he swore under oath that no such interaction had ever occurred. "He had no way of knowing how much we already had," Camille said later, in one of the few extended interviews she gave once the case became public. "If I had confronted him that first night, or filed a complaint immediately without doing the deeper work first, he would have had weeks to prepare a more careful story, to consult with union representation, to figure out exactly what I could and couldn't prove. By waiting, by letting him testify formally before he understood the full scope of what I already had, he built his own trap. I just made sure I had the door ready to close behind him when he walked into it." The formal criminal investigation that followed, now involving not just the State Attorney General's office, but a coordinated multi-agency task force, specifically formed, given the scope of what Internal Affairs' initial review had uncovered, ultimately expanded well beyond Kessler's individual conduct. Investigators, working from the same pattern-based approach Camille had pioneered independently during her own 6 weeks of research, identified and reopened all 6 of the previously dismissed defense complaints, ultimately determining that at least 4 of those 6 cases involved evidence that had very likely been fabricated or planted in a manner substantially similar to what had happened to Camille's own vehicle. 2 individuals previously convicted, based substantially on evidence from those reopened cases, had their convictions formally vacated within the following year, following a joint review process between the Attorney General's office and the county's Conviction Integrity Unit, a unit that, notably, had been established years earlier, partly due to advocacy work Camille herself had contributed to during her early career, a connection several colleagues later described as almost impossible not to notice, given how directly her own professional history intersected with the very process now correcting harm caused by exactly the kind of misconduct she had spent her career working to expose. Terence Boyd, the young man whose case had struck Camille so deeply during her original 2 weeks of research, was among those whose conviction was ultimately vacated, nearly 2 years after he had originally accepted his plea deal rather than risk trial. Camille, though formally recused from any direct role in his individual case review, given her personal connection to the broader Kessler investigation, requested and was granted permission to attend the brief court hearing at which his conviction was formally vacated, sitting quietly in the gallery rather than at any table connected to the proceeding. "I didn't say anything to him that day," she said. "It wasn't my place, and I didn't want him to feel like his case was somehow about me. But I needed to be there. I needed to see it happen, after everything his file had made me feel during those 2 weeks at my kitchen table. Some things you just need to witness, even quietly, even from the back of the room." Boyd, reached separately by a reporter following the vacated conviction, said he had followed the broader Kessler case closely once it became public, and that learning the full scope of what had happened to Camille helped him finally understand something about his own case he had never had proof of before. "I always knew in my gut that something was wrong with what happened to me," he said. "I just never had anything beyond my own word to prove it. Finding out someone else went through something similar and had the tools to actually prove it happened exactly the way she said, that gave me something I hadn't had in almost 3 years. It didn't undo the 8 months I spent locked up, but it gave me an answer to a question I'd been carrying around that whole time, wondering if I'd imagined it, or exaggerated it, or somehow deserved to be doubted the way everyone doubted me back then." Kessler was formally indicted on charges including evidence tampering, perjury, and obstruction of justice, roughly 4 months after the original incident. He ultimately pleaded guilty to a reduced set of charges, as part of a negotiated agreement, roughly 8 months after his indictment, avoiding a full trial, but accepting a formal felony conviction that permanently ended his law enforcement career and included a sentence of 18 months in state custody, followed by a 5-year probationary period, during which he was barred from any employment involving law enforcement or private security work of any kind. Kessler's own attorney, in a brief statement issued following the plea agreement, offered little in the way of explanation for his client's conduct, beyond acknowledging that Kessler deeply regrets the harm caused by his actions and accepts full responsibility for the consequences of that night. Kessler himself declined every interview request in the months following his sentencing and has, according to court records, complied fully with the terms of his probation since his release. The department itself, facing mounting public pressure once the broader pattern of reopened cases became widely known, initiated an independent audit of its evidence handling and internal complaint review procedures, an audit that ultimately recommended, and the department subsequently adopted, a new requirement that any defense attorney complaint alleging evidence tampering or fabrication automatically be logged in a centralized, searchable database, regardless of that individual complaint's outcome in court, specifically to prevent the exact kind of pattern that had allowed 6 prior complaints against Kessler to be handled in isolation over nearly 5 years without ever being connected to one another. That audit also recommended, and the department separately adopted, a new supervisory review requirement for any case in which the same officer's incident reports repeatedly used identical or near-identical language to describe evidence discovery circumstances, a direct response to the pattern investigators had identified across Kessler's prior reports, and a safeguard specifically designed to flag exactly the kind of formulaic, repeated justification language that had allowed his conduct to go unnoticed across so many individually reviewed cases. Camille Reyes, for her part, returned to her regular caseload within weeks of filing her original complaint, declining, throughout the entire 6-month process that followed, to take any leave or step back from her ordinary prosecutorial duties, despite colleagues repeatedly encouraging her to do so, given the personal and professional strain of simultaneously being both a victim and a key evidentiary source in an active criminal investigation. "I didn't want my daily work to stop just because this was happening in the background," she said, "partly because I genuinely believe the cases I was already working on mattered just as much as this one, and partly, honestly, because I think there was something important about simply continuing to show up and do my job carefully and correctly, exactly the way I always had, while this played out. It felt like the clearest possible answer to what had been done to me. Not outrage, just continued, careful competence." She gave exactly one public statement once Kessler's guilty plea was finalized, delivered outside the courthouse, in a brief, measured address that avoided any language of personal vindication or triumph. "What happened to me that Tuesday night was frightening, and I won't pretend otherwise," she said. "But what troubles me far more than what happened to me is how many of the 6 prior cases I found during my own review involved people with far fewer resources than I had, far less institutional knowledge of how to build a case like this, and far less ability to simply wait 6 weeks and gather evidence quietly before anyone needed to believe them. I had the professional tools to make sure I couldn't be dismissed. Most people facing exactly what I faced that night don't have those tools. That gap is the real story here, and it's the part of this case I intend to keep working on long after today." That statement, quoted widely once the case concluded, became a central reference point in subsequent policy discussions at the state level regarding evidence tampering complaint procedures, ultimately contributing to legislation requiring all law enforcement agencies statewide to maintain centralized, cross-referenced complaint databases specifically designed to surface exactly the kind of multi-incident pattern that had taken Camille's own independent, 6-week investigation to uncover on her own. Camille has continued, in the time since, to specialize in officer misconduct prosecutions, taking on, among other cases, direct involvement in reviewing several of the reopened cases connected to Kessler's broader pattern, work she has described as some of the most personally meaningful of her entire career. precisely because of how directly it connects back to what happened to her on that quiet residential street. She keeps, on a shelf in her office, a small evidence bag identical to the one recovered from beneath her car seat that night. Empty, sealed, unmarked. A private reminder, she has said, not of what was done to her, but of the 6 weeks of patient, careful work that followed it. She has, since the case concluded, begun offering informal guidance sessions for younger prosecutors and public defenders in her office, walking newer attorneys through exactly the kind of methodical, patient evidence-building approach that defined her own response that Tuesday night, not as a formal training program, but as something closer to mentorship, born directly out of her own experience. "I tell them the same thing every time," she said. "Your first instinct, when something wrong happens to you or to a client, is almost always to react immediately. Sometimes that's exactly right. But sometimes, especially when you're dealing with an institution that has more resources and more built-in credibility than you do in that exact moment, the more powerful response is to slow down, document everything, and make sure that by the time you do act, there's no room left for anyone to explain it away. That's not weakness. That's strategy. I had to learn that the hard way, sitting in my own car that night, fighting every instinct I had to just get out and confront him. People sometimes ask me if I regret not confronting him that first night," she said. "I don't. I think about what would have happened if I had. A shouting match on a dark street, his word against mine, no evidence properly preserved, no pattern established. He would have called it a misunderstanding, and given how these things usually go, a lot of people would have believed him over me. I didn't need him to believe me in that moment. I needed a courtroom to believe the evidence, months later. Those are two very different goals, and only one of them actually changes anything. If this story made you think twice about patience, about power, and about what it actually takes to hold a system accountable to its own stated standards, do 3 things for us right now. Hit that like button, drop a comment telling us what part of this story stuck with you the most, and subscribe so you never miss the next story of justice, resilience, and the fight for real accountability. 6 prior complaints, nearly 5 years, and it took one prosecutor's 6 weeks of quiet, careful patience to finally connect all of them together and close a door that should have been closed a long time before it ever reached her own driveway. Imagine what could change if every complaint got that same careful attention, not just the one filed by someone who happened to know exactly how to make sure the evidence couldn't be explained away. We'll see you in the next one.